In our case study this week we will review a recent court wrong dismissal, where an employee made a claim in the industrial court that she was wrongfully terminated for alleged poor work performance. In our review we will deliberate the actual issue, the process and approach of the company and claimant's justification, the court's verdict and key learning points. The key issue in this case is employee performance. The parties involved in this dispute are Madam Chong, hereinafter referred to as the claimant, and a company involved jewelry business, hereinafter referred to as the company. The claimant commenced employment with the company as a jewel designer on May 2, 1994. The claimant's last run salary was $118,000 per month. The claimant was dismissed on May 17, 1999 via a letter of termination signed by the company's managing director. For alleged poor performance, the claimant in the statement of case contended that her dismissal was without any cause or excuse, and that she was wrongfully dismissed by the company without any prior notice or warning about her alleged poor performance. The company, through its witness COW1, HR executive, stated that the claimant was dismissed due to her poor performance and state of mind. When asked to explain further, COW1 stated that the claimant, after her delivery, constantly came to work with a negative attitude and was always complaining about her personal and family problems and crying at work. This resulted in an unhealthy work atmosphere at the design floor where the complainant was attached to at the time of her termination, and the complainant's work performance and quality had also declined. The company also claimed that the claimant was counseled and warned about her poor performance, and when there was no improvement in her performance, the company terminated her employment. The claimant stated in her witness statement that on May 17, 1999, she was instructed by the then personnel manager to tender in her immediate resignation, on the grounds of poor performance. The personnel manager also informed that she will be paid 2 months' salary in lieu of notice period. The claimant refused to do so and was duly terminated. The claimant went on further to state that prior to May 17, 1999, the company never commented about her performance, nor was she warned about any poor performance. The claimant mentioned if so her performance was poor, the company should have warned her and given her time to improve her performance. The claimant stated that she has been receiving bonuses and salary increments throughout her tenure with the company. On the question on the quality of her work, the claimant stated the fact she has won numerous awards for jewelry design prior to joining the company and during her tenure with the company should be enough to prove the quality of her work. The claimant does not agree to the reason of termination, that is poor performance, and believes she was wrongfully dismissed by the company. Based on the witness statements and evidence produced by both parties, the following is the court's findings. There was no mention or record of the claimant's poor performance prior to May 17, 1999. If so, the claimant was a poor performer. She was not duly warned by the company, nor was she given the opportunity to improve her performance. The managing director, who signed the termination letter, was not called in as a witness by the company, especially when he has full knowledge of this case. The company could not dispute the claimant's testimony as it was backed by evidence. The company's sole witness COW1 joined the company in 2006, which is almost 7 years after the claimant was terminated. In fact, she admitted in court that she had no personal knowledge of this case other than referring to company records. Based on these, the IR court ruled that the termination of the claimant was without just cause or reason, therefore the IR court ruled in favor of the claimant. The case above shows that the company did not follow proper procedure in managing the alleged poor performance. If at all the employee is not performing up to expectation, it is the responsibility of the company to inform the employee concerned about her poor performance, and highlights areas for improvement and provides the opportunity for the employee to improve. After all these fails, then only should the company consider a more serious disciplinary action, which can include termination. The company actions clearly indicate a lack of knowledge in employment regulations, where the HR manager can actually instruct the claimant to resign due to poor performance. The rule of thumb for any HR manager professional is you never request, instruct nor force an employee to resign under any circumstances, and as in the case above, the company will be exposed to unnecessary labor disputes. The case above is a fine example of what happens when there are no proper HR policies and procedure in place to manage performance or any other employment issue for that fact. A lot of employers, especially the SMEs, are also quite ignorant of our local employment legislation and have a if I can hire, I can fire attitude in managing their people resources. The fact is, one of the pillars of success in any business is the people, and it is only good business sense to have in place and good HR practices to manage the people resources effectively. This then shall provide the business the required competitive edge.